He was about to face trial. Victims were prepared to speak. Then prosecutors made a deal €1. And no one was told. No public fight. No full trial. Just a signature. And he walked away. In 2008, a powerful man signed a deal. No federal trial. Limited jail time. Details kept from victims. Years later, when the agreement became public, outrage exploded. People asked one question. How does this happen? Here is the uncomfortable answer. A courtroom is not built on emotion. It is built on leverage. One side pushes. The other resists. The rules are the same on paper. But access isn't T. One defendant meets a lawyer days before court. Another assembles a team for months investigators, former prosecutors, forensic specialists. Preparation creates pressure. Pressure creates options. And most criminal cases don't end in a dramatic verdict. They end in negotiation. When risk is high, both sides calculate. So when a wealthy defendant secures a deal that feels light, suspicion follows. Is it corruption? Or is it a system that rewards whoever can navigate it best? Theta is where doubt begins. Jeffrey Epstein became a global name long before his final arrest. In 2008, he pleaded guilty in Florida to state charges involving solicitation of a minor. He served jail time. Registered as a sex offender. Received probation. Prosecutors called it lawful discretion. Critics called it unusually lenient. More than a decade later, federal prosecutors filed new charges in New York. The allegations were broader. The scrutiny was intense. Before trial could begin, Epstein was found dead in his jail cell. Authorities ruled it a suicide. For some, that closed the story. For others, it deepened suspicion. His social circle included politicians, business leaders, academics, celebrities. But association is not proof. A photograph is not testimony. A name in a log is not a conviction. Still when wealth, influence, and a controversial deal intersect, doubt spreads fast. Was the 2008 agreement a failure of justice? Or proof that structural imbalance can shape outcomes without breaking a single rule? The events are documented. The meaning attached to them is where division begins. Now consider a different stage of the legal process. Unlike a concluded plea deal or a closed investigation, this situation is unfolding in real time. Sean Combs has faced multiple civil lawsuits alleging serious misconduct. Civil cases are filed by private individuals seeking damages. They do not require the same burden of proof as criminal trials. They do not result in prison sentences. They operate under a different legal threshold. At the same time, reports have confirmed federal investigations connected to some of these allegations. An investigation is not a conviction. It is a formal process designed to determine whether sufficient evidence exists to bring criminal charges. But in the public arena, that distinction often collapses. Once allegations become headlines, reputations shift immediately. Social media reacts within minutes. Sponsors reconsider partnerships. Audiences form conclusions long before a judge ever hears a motion. The legal system moves deliberately. Public judgment moves instantly. So a difficult question emerges. When accusations surface against someone wealthy and famous, does money provide insulation? Access to top-tier attorneys certainly becomes available. Public relations strategies are deployed. Legal teams can challenge filings, negotiate settlements, and scrutinize procedural details. Resources increase options, but they also increase visibility. High-profile defendants face intense scrutiny. Every filing is examined. Every statement becomes news. Pressure builds from multiple directions: legal, financial, reputational. Does wealth soften consequences? Or does fame amplify risk? History offers examples of powerful individuals who avoided conviction. It also offers examples of powerful individuals who were convicted despite immense resources. The existence of money does not predetermine outcome. What it changes is the battlefield. Civil lawsuits can be settled without admission of wrongdoing. Settlements are legal tools. They may reflect strategic decisions rather than proof. Yet to the public, a settlement can feel like confirmation. At the same time, the absence of charges can feel like exoneration even when investigations remain ongoing. The law draws sharp lines between allegation, charge, indictment, trial, and verdict. Public discourse rarely maintains those distinctions. This gap creates instability. If someone is accused, many assume guilt. If someone is wealthy, others assume protection. When both conditions exist together, suspicion intensifies. But the presumption of innocence is not symbolic. It is foundational. Without it, accusation alone becomes punishment. That principle must apply consistently whether the defendant is unknown or internationally famous. Still, we cannot ignore another reality. Legal defense at the highest level requires enormous funding. Complex litigation can stretch for months or years. Expert witnesses, forensic reviews, and procedural challenges demand time and money. Few individuals can sustain that level of resistance. So the tension returns. Is the system unequal because wealth allows deeper defense? Or is it functioning as designed, with disparities rooted in broader economic inequality rather than legal bias? In ongoing cases, patience becomes uncomfortable. Evidence has not yet been tested in full view of a jury. Charges may evolve. They may strengthen. They may collapse. Until that process completes, certainty remains premature. And yet, in the public imagination, certainty often arrives first. Stepping away from individual names, the broader issue remains. Human trafficking is not a theory. It is documented reality. International organizations report thousands of confirmed cases every year. Victims include women, men, and children. Exploitation takes many forms: forced labor, coercion, sexual exploitation, debt bondage. The problem spans continents. It crosses borders. It adapts to economic conditions. Yet most documented trafficking cases do not involve billionaires, celebrities, or political elites. They involve regional criminal networks. Recruiters operating in vulnerable communities. Smugglers exploiting poverty, instability, and lack of protection. This does not minimize the horror. If anything, it complicates it. Because the public imagination often gravitates toward a simpler structure, a pyramid with powerful figures at the top orchestrating everything below. Why does that narrative feel persuasive? Perhaps because large-scale suffering seems too massive to be fragmented. Chaos is harder to process than hierarchy. A centralized villain is easier to confront than a decentralized system of exploitation driven by economics and opportunity. But investigations repeatedly show something less cinematic. Criminal networks operate in cells. They cooperate temporarily. They compete. They dissolve. They reform under new names. There is coordination in specific cases. There are organized rings. There are corruption scandals at various levels. Yet evidence rarely supports the idea of a single, unified global command structure. That distinction matters. If every trafficking case is interpreted as proof of a hidden elite network, resources and attention may shift away from where most exploitation actually occurs in vulnerable regions with limited oversight and weak institutional support. On the other hand, ignoring the possibility of corruption among powerful individuals would also be naive. History has documented cases where wealth and influence intersected with criminal conduct. So the tension persists. How do we confront a real, documented global crime without inflating it into an all-encompassing conspiracy? How do we remain vigilant without abandoning standards of evidence? The scale of trafficking is tragic enough on its own. It does not require embellishment. But emotional intensity can blur categories. A single confirmed case involving a powerful figure can reshape public perception of the entire landscape. At the same time, thousands of cases involving unknown perpetrators rarely receive similar attention. Does visibility distort understanding? Or does it simply reveal a deeper distrust of power? The challenge is not to deny the existence of evil. The challenge is to analyze it accurately. Because solutions depend on clarity. And clarity requires separating documented patterns from imagined structures. Cultural reactions often reveal how society processes fear. The film A Euro Sound of Freedom Euro became more than a movie for many viewers. It represented resistance. It symbolized protection. It framed trafficking as a battle between clear heroes and obvious villains. Stories built that way are powerful. They create direction. They offer emotional clarity. They suggest that evil can be identified and confronted directly. Reality rarely unfolds with that simplicity. Investigations take years. Evidence moves slowly. Outcomes depend on procedure, not momentum. Yet audiences respond strongly to narratives where justice feels immediate and decisive. Is that response a desire for accountability? Or a desire for certainty? When powerful names appear in headlines whether in concluded cases or ongoing investigations the emotional reaction intensifies. Anger rises quickly. Distrust expands. Patterns are drawn before evidence is fully tested. At the same time, documented convictions of wealthy individuals show that power does not guarantee immunity. The record contains both controversial deals and decisive sentences. So where does that leave the original question? Money increases access. It strengthens defense. It expands strategic options. But it does not automatically erase evidence. Influence can shape perception. It can influence negotiation. It can delay outcomes. Yet final judgments still depend on proof presented under legal standards. Justice, then, may not be something that can simply be purchased. What money can buy is time, expertise, leverage. Whether that ultimately changes outcomes depends on facts not assumptions. And that distinction matters. Because if we assume every powerful defendant is protected, we risk abandoning the principle of evidence. If we assume wealth never affects outcomes, we ignore structural inequality. The uncomfortable truth lies somewhere between certainty and denial. So perhaps the better question is not whether money buys justice. Perhaps the real question is this. In a system where defense depends on resources, how close can equality ever truly be? The answer is not simple. And it may never be absolute.